Reliance was placed on a judgment of this court in New India Insurance Company Limited v. Krishna Kumar Pandey in support of the contention that an application for recall is maintainable when the order is passed without jurisdiction full stop. The respondent in the said case was convicted for an offence punishable under section 1498A of the Indian Penal Code, 1860 IPC, and was sentenced to rigorous imprisonment for 1 year full stop. Next para, the appeal filed by him was dismissed by the Session Court, against which he filed a revision petition under section 397 CRPC before the High Court full stop. The revision petition was partly allowed by the High Court and the sentence was reduced to the period already undergone full stop. The High Court also held that the conviction shall not affect the service career of the respondent. Advisory full stop. The appellant filed an application for correction of the order passed in the revision petition, which was dismissed full stop. Next para, the respondent employee submitted before the High Court that the order cannot be modified full stop. The High Court accepted the submission of the respondent employee in that case and dismissed the application against which the appellant approached this court full stop. This court was of the opinion that the High Court acted in excesses of its jurisdiction in holding that the conviction shall not affect the service career of the respondent therein full stop. Next para, by referring to an earlier judgment of this court in state of Punjab v. Devinder Pal Singh, it was held that inherent power of the High Court under section 4082 CRPC was available to pass suitable orders where an order is passed without jurisdiction or in violation of the principles of natural justice full stop. The said judgment has no application to the facts of this case full stop. By no stretch of imagination can it be said that the order dated 4/5/2020 suffers from the vice of lack jurisdiction. Yet another ground raised in the appeal is that an application for recall is maintainable when principles of natural justice are violated full stop. A pursuit of the order dated 4/5/2020 discloses that the appellant and the other contenders were heard before the applications were dismissed full stop. Therefore, the contention of the appellant is without any substance full stop, as we are concerned only with an application filed to recall the order dated 4/5/2020. It is not necessary to examine the submission made by Mr. Sorkar that the judgment dated 27/4/2020 has been impliedly overruled by a later judgment of this court in Prashant Bhushan case full stop. We are in agreement with the order passed by the Registration Administration holding the application for recall of the order dated 4/5/2020 is not maintainable full stop. Next para, this court in Delhi Administration v. Gurdeep Singh depreciation the practice of filing of applications for clarification, modification or recall of final judgments or orders full stop. It was held in the said judgment that a party cannot be permitted to circumstances or bypass review and indirectly obtain a hearing in the open court by filing an application for modification or recall full stop.